Welcome, everyone. It's great to have you all here at this 4IP Council's webinar called The Telos Version Trilogy or Re-Recording music albums legally possible in EU too. My name is Axel Frazzini, and I'm the Managing Director of 4IP Council. I'll be your host today. As you may know, and I'm sure that you know, 4IP Council is a not-for-profit organization, and we are focused on the link between IP and innovation. Our mission is to identify the most relevant topics and produce empirical research by collaborating with a variety of academics, experts, IP organizations, and other stakeholders. On our website, you can find plenty of free materials. For example, studies, summaries of relevant papers, recordings of our webinars, such as today, and podcast interviews, now featuring a sustainability special. We also produce easy to digest content at the P, the 4 reasons for SMEs corner, especially tailored for non-IP experts, SMEs, and startups. We also have a new area on our website called IoT and Cellular Standards Made Simple, where you can learn about the benefits of standards and IoT across different sectors. I suggest that you check it out. And if you have any feedback, please send them to us. So now you can follow us on X, LinkedIn, Instagram. Our handle is simple, 4IP Council everywhere. There you can find more news about what we are doing, the resources, the interviews, and as well the future webinars. But without further delay, it is my pleasure today to introduce you, our speaker, Dr. Maria Daphne Papadopoulou. Dr. Daphne Papadopoulou is currently the acting director of the Hellenic Copyright Organization. She is a member of many copyright and IP committees and a national expert in groups for copyright and IP. She is an author of numerous contributions in books and articles in Greek, English, and German. She has presented many papers in national and international conferences and gives lectures on copyright issues. At the same time, she is a copyright expert working as a freelance attorney, consulting on copyright and general IP issues, and as an accredited mediator. So a final remark for the audience. Please do not hesitate to use the Q&A tool that you can find at the bottom of your screen. And you can raise your questions anytime during the webinar. Please, if you do it early, I will make sure that your question will be taken, and the presentation and the recording will be made available tomorrow. Without further delay, Daphne, the floor is all yours.
So good afternoon, everybody. Good afternoon for a very hot Athens. Here we have something like 42 or 43 degrees. And I would like to thank you for being here present and spend 1 hour listening to me and the very interesting topic that the 4IP Council proposed to me, which I'm really thankful for the invitation, of course, and for this very thought-provoking topic about Taylor Swift. And special thanks to Claudia Tapia that she's not listening, is not present, and of course to Axel Ferrazzini that he's very kindly accepted to be my moderator, and of course to Marta Sierra that she took care of all the administrative and not only staff. Unfortunately or fortunately, I don't know, we will be giving this lecture remotely because I just read that Taylor Swift gave she was in Edinburgh and she was causing an earthquake actually because of her performance. So probably we won't have this effect, my speech, but I hope that it will make a little bit more clear what all this issue is about. So let's start and say, what do they have in common? Apart from the obvious, Taylor Swift, Frank Sinatra, Prince, and Def Leppard. All of them, they have re-recorded their albums. Okay, then the next question, of course, will be, and why are actually we're talking about Taylor Swift? Because Taylor Swift seems to have done it the best way. And her recordings are outperforming the originals by a landslide. And from a business perspective, re-recording was an incredibly smart move for Swift, because not only does this gave her full commercial licensing power of her music, but from just to give you some, let's say, elements, because there are plenty, the Fearless, Taylor's version, because this is how she renamed her recordings, was the first re-recording album that made it to the Billboard charts. The Red, Taylor's version, broke the Spotify record for the most streamed album by a female artist, and Taylor Swift herself became a billionaire in 2023. And for another reason that we will see it later in the presentation. Another reason that we are talking about her is that she seems to swim against the tide. And what the tide is, the latest trend is the music right acquisition. Only in 2021, there was spent more than $5 billion on the catalog acquisitions. Many and very famous songwriters, they decide to sell their repertoire to catalog. And there were really a lot of money invested in acquiring this catalog. And just to name the Bruce Springsteen, Sony Music had to acquired his catalog for 500 million, or the Mötley Crüe was acquired from the BMG, and all this seemed to be in quite opposite what Taylor Swift. She really wants to take control of her music, of her repertoire, and she's doing everything possible to hold really, really tight to it. So let's see very quickly about the background to know what we are talking about. So it was back in 2005, then the Swift signed a recording contract with the Big Machine Records. And the contract was for 6 albums and gave Big Machine ownership of all master recordings for those albums. And this is really the rule, all it used to be. When the contract ended, Swift would be able to re-record her music after, of course, a set period of time, if she wished. So Swift's contract with Big Machine ended in 2018 when she released her 6th album, Reputation. She did have the opportunity to resign with Big Machine, but in the offer, Big Machine gave Swift the opportunity to earn back her master recordings, 1 album at a time, for every new album she released. Swift didn't like so much this offer, so left the Big Machine and signed with another company, a subsidiary of Universal Music Group. Her new contract gave her the ownership of all the master recordings that she will create. So back to Big Machine. In 2019, Big Machine was sold to a company that was owned by her, let's say, one not so close friend from Taylor Swift, Scooter Braun. She really was she was not at all enthusiastic about this. Also, she didn't had the opportunity, even although she wanted, and she expressed this desire to buy her own album or the company. And afterwards, Braun actually sold this to the company and the albums to a fund. And following this acquisition, the company wouldn't allow Swift to use any of the music in her 2020 Netflix documentary Miss Americana. And this, I think, really was the last straw on the camel's back. Here's some music, some songs of the Taylor Swift that really, really match to this kind of situation. I would just point out the Mad Woman and the how did it end, because this is really matters. So in an attempt to regain ownership and control her early music, Swift announced that her intention to record her first 6 albums. And she has already re-recorded 4 albums: Fearless, Red, Speak Now, and Taylor's and 1989, and all of them there's Taylor's version. And the only 2 she hasn't yet recorded is Taylor Swift and The Reputation. Thus, it was very successfully said that all she has left to recover are her name and her reputation. So let's see now. We will see now. I'm sorry. Before going to see the EU copyright law, just two points. Why did she want to re-record her albums? I think the first was, it's very obvious, apart from being a very mad woman, she wanted to re-record her albums in order for regain financial control. By re-recording, she could take ownership of her work and receive revenues from her copyright, royalties, licenses, and licenses. The second reason is beyond this financial incentive, re-recording would allow her to revisit her song, give them some other new features, and all this re-recording project as a whole caters to all fans who were there for the release of the originals, and while simultaneously she ropes in new, younger fans. So let's go and see about the EU copyright law. And we will focus in the EU and not in the relevant US legal framework. There are plenty of articles in the internet analyzing this Taylor Swift move. And I have to mention also that Taylor, there's the specific category saying Taylonomics or Swiftnomics, and she's also taught in 3 American universities, because really her choices is really affecting the whole music industry. And we will underline some US features from the EU law as we want to juxtapose it with the EU law. So let's see very simply what rights are involved. Because when we have ingredients actually from a song, we have the music, the lyrics, the performance, and the phonogram itself. The lyrics and the music, both of them, belong to Taylor Swift, because majorly she's the only lyricist and composer of her music. Also, she is the performances, singing herself her music, and the only thing that she hasn't done it was to do the producer of the phonogram. And I give you, let's say, the legal framework, but I didn't want to make too technical. So really, I give you some general the articles from the EU directives and also from international treaties. What we have there, actually, this a bundle of rights given to the songwriters, to the authors, and to the producers of phonograms. Just to mention now, the phonograms in the States, they're calling them a recording and a sound recording. And let's see, what do they have, what authors have as rights? They have exclusive economic rights to the production, communication to the public, making available, rental and lending rights. They have distribution right, broadcasting, and they have an adaptation right, although this is not harmonized at the EU level. And of course, they have levies from the private copying exception. And the owner now of the phonogram has, on the other side, they have some other exclusive rights, as communication to the public, making available, rental, lending rights, distribution right, and also the case that the phonogram is used for the broadcasting and the communication to the public, they are entitled for a single equitable remuneration that is shared between the performers and the producers of the phonograms. And of course, they have also the entitlement also to the private copying levies. I would like to make now here a small, let's say, very legal parenthesis, because we were discussing this subject with a Greek law professor, and she was saying to me, yeah, but who is the producer of the phonogram? Because this is quite important. And so if you go to the international convention, to the Rome Convention or the WPPT, you see there that the producer of the phonogram is the person or the legal entity who first fixes the sounds of a performance. So in this case, especially when you're making the re-recording, there was a question, a legal question, very dogmatic maybe. It was a question, does have the new producer of the phonogram, does he establish a right? Because maybe he will say someone is not first fixation. I searched for this, and only the German literature was legal literature was mentioning things, and actually it was said that the first fixation does not mean the first time a particular work has been recorded, nor does it mean that exclusiveness of this recording of a particular performance. The protection of the phonogram producer is based exclusively on this effort, on this investment that he's doing for this fixation. So regardless of whether, for example, the same performance, the same sounds are also recorded by third parties. So the fixation, the first fixation means that the first physical incorporation of a presented of a sequence of sounds. So from which copies can be made that made in that much in terms of content and quality. So the recording of a performance of a successful work, that means a cover version, that's sometimes a very successful song, is again recorded by another performer, another singer, and it's changing a little bit the musical arrangement. And if you have this recording, of course, then we have a new right of the producer of the phonogram. And also a new right is you have when you have a re-recording, even when in the re-recording, the sound is meant to be exactly or very close, very similar to the original version. Another interesting but very dogmatic discussion, and we won't go towards this direction, is whether the fixation is a reproduction. Just keep it very short and say that legally it's not considered as a reproduction, but it's a prerequisite to start the reproduction right of the producers. Let's cross the ocean for a moment and go back to the States. I said before about the cover version of a song, although now we don't have this kind of, this is not the case, but it's interesting enough and to see why you have this recording restriction in the contracts is that in the States, anyone may copy someone else's musical work, even without an express licensing from the copyright owner, from the right holder, so long as the copier pays a royalty to acquire a compulsory license. So they have in the States, they have a compulsory licensing scheme authorized by the section 115 from the US Copyright Code, where anyone is entitled to make a mechanical reproduction of a copyrighted musical composition if they pay a statutory fee. And also, according to section 114, a new re-recording, sound recording, or phonogram, let's say, in the EU, may exactly imitate another copyrighted sound recording, and there is no problem. So a re-recording of a song does not infringe the original sound recording, even though such sounds imitate or simulate those in the copyrighted sound recording. So in a sense, what they do, the copyright law in the US permits artists to give new life to music, despite not owning maybe the copyright to the musical composition or the sound recording, the phonogram. But in the States, they are not allowed to actually copy the sound recording. So the sound recordings are explicitly excluded from this compulsory licensing scheme. In order to preclude Taylor from prematurely re-recording, which of course would lead to will devalue the copyrights assigned to the label, the contract contained this re-recording restriction clause, having an effect for a certain period of time. And now we come to the contract law. And because apart from the re-recording restriction that the contract law has, the author usually transfers to the producers of the phonograms some rights, and can, in exchange for this, the record company gives artists royalties or a percentage of the income earned through the streaming and the sale of the song. So the main sources of this royalty revenue are mechanical royalties generated through the physical and digital production of a work, performance royalties generated through the public performance of a work, synchronization royalties generating through licensing their work to be paired with film, television, commercials, or even video games. So all these rights that we were mentioning at the beginning, the rights of the authors, and also, of course, the rights of the producers of the phonograms, gives this different way of exploiting the musical work. And this is the main source of the revenues. Of course, there are also some other sources of revenues, but we won't go analyzing them. So as it becomes clear, the owner of the recording can generally exercise the most control over the music, how the recording is to be used and exploited, including whether to license the recording for use in films, or how the music is to be released for sale and use on streaming platforms and through other distribution mediums. So, and given the control and potential profit associated with this right, record labels, the phonogram producers often negotiate terms with artists where they retain ownership of the masters in exchange for the payment or of upfront cost of making the recording. But what about moral rights? Moral rights guard this creator's personal connection to the work. They allow them to control the integrity and attribution of their creation and are maintained even after economic rights have been transferred. So moral rights are very strongly recognized in EU and protected, but very, very weakly embedded in the EU-US law. So the US only recognizes some moral rights to creators of certain visual arts. They have the VARA Act. Then the limited scope of these moral rights in the US meant that thrift have trying this recourse to regain control was confined to the strategic use of economic rights. If the dispute, if the Taylor Swift was from Europe and this was taking place in Europe, all this in this dispute, she might have an additional legal weapons. And of course, for example, in Greece, there is a provision that doesn't allow, give the possibility to the author not to approve the transfer of the exclusive rights to a third person without his consent. So if the author has given exclusive rights or he has transferred the right, somebody cannot transfer cannot transfer these rights without the consent of the author. And similar provision exists also in Germany, in Spain, in Sweden. So this could be these rights of paternity, integrity, as well as the rights of disclosure and withdrawal, the moral rights, could have made up a strong case. We said at the beginning, let's see now the impact on the record label. We said at the beginning that there was one more reason that we are talking about Taylor Swift and not the others. And the reason is that there was an impact on the record label. In response to this swift success in her recording project, major record labels, producers of phonograms, are changing the recording contracts for the new artists. So the labels want to ensure that artists maintaining exclusivity with them and are preventing them from competing with the record labels by re-recording. And labels like Universal Music Group or Sony Music and Warner Music Group are stipulating that they have to wait anywhere to 10 to 30 years after the original contract ends to re-record their music. Will they get 30 years? Probably not, but you have to have a good lawyer. In any case, they want this, if you have this approach, they want to make sure that the artist's vocal cords are not in a good shape by the time they get around to recording. So it's important to recognize that these recording restrictions are not new, but it used to be something like 3, 5, maximum 7 years, and now they're changing to a much longer term. And this also, it was not that at the beginning. The first time I think they started to have this re-recording restriction, it was back in the 1960s, because then group Everly Brothers left their label Cadence in 1960 to for $1 million deal with Warner Bros. And after this, there was really a big story. A big story. There was that they have the re-recording of their repertoire with Warner Bros. And after this, re-recording restriction came and it was used in their contracts. Another reason is that this swift strangle with the big machine that was made in public was affecting also new artists. And they are trying, the new artists, to choose to sign some contracts with the record labels. And they were trying to negotiate in order to own their master recordings. And there are some songwriters that have made this, and they was stating that they were inspired by Swift's battle with her own music, like Olivia Rodrigo is an example. And let's finish and with solutions. Maybe one would ask, is it necessary actually to have a contract with a record label? To have a contract with a phonogram producer in the time of TikTok and Spotify? Not necessarily. Before the internet, the artists were used to be much more reliant on music labels to release their music and promote their work. Now there are cases that they are able to do even without these records. But surely, although this tendency, the fact that they are not anymore, that they are this TikTok and all this, is changing a little bit also the nature of the contracts. Sometimes in order this very traditional contract that they sign the artist with the record label, but also they having contracts that have to do only the promotion, for example. In any case, it will be a very, there are some ways that could go around this problem, and not only by making a longer re-recording restriction. One possible solution could work for both the labels and the artists, is to give the rights to the master recordings to the labels, and then transfer ownership to the artist after a set period of time. After the first few years, the music is released, the record labels usually have earned the majority of royalties they are going to make from the music, and could be content transferring ownership to the artist. And this, I have made some discussions with Greek record labels, not only Greek, it was part actually from international record labels. And I think this is how the music industry goes right now. It seems that is something that is start applying even more often. The second is could be for the record labels to give artists an increased say in decisions regarding their music. Artists could negotiate, of course, in the recordings contract that the state, that's it, that both parties must mutually agree on any decisions made about licensing or sales or any other actions pertaining to their work. And so shared decision making could benefit both parties, as artists could retain creative control, while of course on the other side allows record labels to participate in strategic decision. So I think from what we have said, it's clear that it's very, very important, finally, because it's all about contract at the end, to have a good lawyer, because you never know when the next Taylor Swift will arise. So thank you. And I hope it was clear enough. And I will be at your disposal if you have any questions.
Thank you so much, Daphne. I love this story. I mean, I learned a lot, actually, from Taylor Swift. But so let's, yeah. So let's just remind to the audience that you have the Q&A tool at the bottom of your screen. Please ask any question. And we will start with the first one, which is, would the situation be different if Taylor Swift was only the singer, the performer of the songs?
Yes, because although there is this re-recording restrictions apply also only to performers, it's make her case more easier for her, because she didn't have to ask for the license from the composer and from the lyricist. She was the one. So it was she didn't have to ask the permission. And this would be, in this case, if she wasn't the lyricist or the composer, she had to ask also for the permission to get the license to make these new recordings. That will make the things a little bit more complicated.
Okay, great. And from an EU perspective, could the Article 18 of the DSM directive be relevant for this kind of cases?
Oh, yeah, nice, interesting one. Not only Article 18, but also Article 19 and Article 20. Just to give you an idea, actually, generally, the EU is much more tries to provide more bargaining power to authors and performers. And we have also a very strong legal framework for collective management organization that suppose helping towards this direction. But also the DSM directive, one big chapter and very important chapter of the DSM directive was exactly this, in order to introduce rights to fair remuneration for authors and performers. And Article 18 exactly was saying that it will be very it's like a general principle that authors and performers who license or transfer their rights, they have to have some appropriate and proportionate remuneration. So it's a general clause. Of course, member states have to implement it and interpret it in differently, maybe in every legal order, but this is the general rule. But more interesting is Article 20 that have an adjustment mechanism. What do we mean by this? That actually, if they have they have the possibility for the authors or performers to claim additional appropriate and fair remuneration from the party with whom they have entered the contract for exploitation, if the remuneration that they originally have agreed, it's not is disproportionately low, because probably afterwards the work is becoming a success. They had a very, very low remuneration. So this article gives the possibility to the authors, to the performers, to renegotiate in order to have this appropriate and proportionate remuneration. So if Taylor Swift, she was here and she was bound by this kind of contract, she will have, let's say, the means in order to go against this record company.
Interesting.
Mm-hmm.
Next one is it necessary in order to establish a new neighborhood right for the photogram producers that wants an older album to be somehow different from the first recording?
No, there is a discussion in Germany that maybe this new re-recording should be a little bit different, even from qualitative perspective, or to have some new elements. But I think the answer is clearly that it doesn't have to have this kind of difference, even in qualitative perspective.
Okay. I'm not sure if you have covered this in your presentation, but let's try to clarify this. How does Taylor Swift decision to re-record earlier albums impact her ownership and control over the master recordings?
I'm sorry, I didn't listen.
So
How is the decision?
How is the decision that Taylor Swift made to re-record the earlier albums actually impact her ownership of the master recordings?
Okay, the master recordings, actually, they're still the original are owned by the successor in title of of the company that the first she had the big machine. So the original recordings are owned by the successor in title from the big machine. It's gone from this fund. So they don't change. They are two different master recordings, but the new recordings is Taylor's version. And this, something that I didn't mention, is that not only the Taylor Swift was very successful with her own master recordings, a new Taylor's version, but this had a negative effect to the original recordings. So the more the successful was the Taylor's version recordings, the worse was for the original recordings.
Okay, but for how many years actually the owner of the original masters can keep the ownership?
Okay, in the States, it's a little bit complicated. It depends when it was released. It's something like 75 or 95 years after they make the public. In the EU, it used to be 50 years, but there was a directive, a term protection extended. It was now to 70 years. But there is 20 years, the last 20 years, it has a use it or lose it. So if the record company doesn't use this phonogram, doesn't exploit it, doesn't have anything to do, then the performer can take this right and go to another, let's say, a record company in order to exploit it. So it's also to us a little bit complicated, but there is an extension.
Okay, so now the question is, just imagine I want to license the music of Taylor Swift. Can I go to the original master to take a license, or I have to go to the yes?
No, but this is the success of Taylor Swift, because she's so close to her fans, or her fans are so close to her, and it was so public all this dispute that they had with the previous company, that she decided that she was really urging her fans to follow her, to listen to her song, to the Taylor's version. So this had also an impact. So it was always I think it was quite decisive also which version to choose.
So what if the latter licenses the songs for considerably lower price? I mean, if the original master decides to license the song for very inexpensive price.
Yeah, listen, for copyright perspective, this doesn't seem to be a problem. I don't know, it would be unfair competition. Because somebody would say that's, yeah, competing only under this perspective. But from copyright perspective, this is not a problem.
Okay. And so this question is a bit long, so I will try to read it correctly. If the original recording agreement contains an exclusive assignment clause in favor of the record label, do you think re-recording those same musical works will collide with such original exclusive license?
I'm sorry, I would ask you to repeat it one more time.
Yeah, that's a bit long. So if the original recording agreement contains an exclusive assignment clause in favor of the record label, do you think re-recording those same musical works could collide with such original exclusive license?
No, is exactly this is the point. Is the exclusiveness is the restriction doesn't have to go necessarily with exclusiveness. It's the is a re-recording restriction. You are not allowed to recording a new one. It doesn't have to do with its exclusive or not. Probably if it's not exclusive, then you don't have a problem to record somewhere else. And that's why we have the recording restriction, not to go somewhere else. Because otherwise, if you didn't have the copyright law, both in EU and US, it would be allowed. You will have only problem from competition. So it doesn't collide because it's something completely different, let's say.
Very interesting. And will not it be considered as abusive, a re-recording restriction for a 30 years term?
Oh, this is a nice one. This would be interesting. We had a case, we had two cases in Greece. We had that it went to the court. And the one was a very, very famous singer, but only singer. She was only singing the songs. And she had a 15 years restriction on re-recording the songs. And she was a little bit annoyed and went to court. She lost. She had 15 years re-recording restriction, and she lost both the first and the second appeal. So also in the appeal, and she lost. But there was another Greek singer and songwriter who was singing his own songs that also, with the more or less similar terms, took the case to the courts, and he won. So it's very much up to the courts, and very much up to the concrete circumstances. From my personal view, if you have something like 30 years and you are the songwriter, and it's very possible to be abusive, but yeah.
Okay.
It depends on the circumstances.
Nowadays you have a lot of song contests, and what sort of recommendation will you make to somebody who wants to become a singer and they are ready to accept any type of contract? But if you have two recommendations regarding the contract they should accept, from restrictions perspective, from what type of very important points they should pay attention.
Yeah, the first thing, go find a good lawyer. Okay, let's put this aside. Not you have to be honest. It's everything about negotiation. What negotiation strength do you have, and how strong you can, let's say, go for your rights and impose what you want. So it's very much up to it. But generally, it will be good, and I think it's going towards this direction. But it depends also on the circumstances. If you are a singer that you don't have anything, you don't have because nowadays you can also record your own song. But if you don't have this capability, you don't have any network, you don't have anything, and you just have a beautiful voice, and you went to the record label, I think the most the wisest thing is indeed to have a little bit more typical contract with them and give them some rights, but for a specific period of years, not more, let's say, than 5 years, because within 5 years, the record companies most of the time are possible to take back all the investment, all the money they have invested in you. So be sure that you have a very concrete period of time in this kind of contract. But really, apart from, okay, I was a little bit making a little bit fun, but you have to really, in these cases, it's good to have a legal advice in order to be sure that you'll be on the right track.
Thank you so much. I think that could be the conclusion, because willing to be a singer is great. Having a great voice is fantastic, but clearly you need to have the good lawyer too, to make sure that you will have. Okay, so now, because we are approaching to the end of this webinar, I would like to just thank you very much for your presentation.
Mm-hmm.
I mean, it will impact lots of people, right? Not everybody is Taylor Swift, so we have to be very careful. I would like to just remind to the audience today that we have some new webinars coming up, and especially I would like to steer your attention to the next webinar that will take place in June as well. It will be on the 26th of June on a totally different topic, which will be about quantum, patents, and startups. The goal is to see, as indicated by the title, IP in Quantum Technologies, Europe's Startup Edge in Global Innovation. You will learn from 2 startups and the EPO that will be explaining the latest trends regarding patents and quantum technologies. Finally, I would like to remind you all that tomorrow you will receive an email inviting you to complete a 1-minute survey about this webinar. So that will be very nice if you can answer it. And if you have any topics to suggest on which we should organize a webinar, please do. We are always listening to all the comments that we receive. Thank you again very much, Daphne, for your sharing. And I wish you all to have a good day.
Thank you. Bye-bye.